To be clear, this is a motion to compel discovery. And Bradley Moss, as I was reading through it, I was thinking, can the government simply say, we already responded with that discovery, or we looked and there's nothing there?
Sure, absolutely. Part of their response, no doubt, will be to say, here's everything we did to find discoverable Brady information in compliance with our obligations. Here's how we define the scope. Here's why we concluded it should be defined that way. And here were the efforts we made to produce that information. But reading through this motion, I was thinking of the quote, when you don't have the facts, you argue the law. When you don't have the law, you argue the facts. We don't have either, you pound the table and you yell. That's what this motion is. It's a political talking point and narrative dressed up with legal arguments. They don't really expect, as far as I'm concerned, they don't expect to find this evidence of collusion if they were to get some of this extra discovery, trying to find Brady information in communications with the White House and Hunter Biden and anybody else that, the DOJ may have spoken to in the last 3 years. They want to drag the process out. That's their point with this, is to try to see if Judge Cannon will agree with them to expand the scope, to require some additional discovery, and to produce more information that would take longer to get through. That's their goal with this. I don't really think they expect to find a whole lot of interesting information. They just want this to take longer.
Bradley, one of the notes they have in here is their indication that Donald Trump still had a security clearance. They maintain that there's evidence through the Department of Energy that Donald Trump had a security clearance. How would that be in any way relevant to the illegal possession of classified material? People with security clearances have been prosecuted for taking this stuff home before.
Yeah, so let's get one thing really clear, and I keep seeing this in the Trump filing because it's driving me crazy. Presidents do not have security clearances. They are constitutionally exempt. You are the president of the United States. You are authorized to see anything and everything you want that is classified under executive order. So when Donald Trump became president and up until the day he left, he was authorized to access everything. He didn't go through the vetting that Andrew went through, that I went through, that any number of people who've held security clearances go through. He didn't fill out security paperwork. He was automatically accessed. But of course, the government documents that the president was given access to these particular documents at this time because they have to track where things go. That's all that was. But they've concocted this theory that if he still had, quote unquote, a clearance post-presidency, it meant he was authorized to have these documents. No. Chelsea Manning had a clearance. She didn't have authorization to give out stuff. John Kiriakou had one. Harold Martin over at NSA, who was hoarding documents for years. They all held clearances. They were not allowed to take those documents and put them somewhere else. They were not allowed to store them at home, which is what Donald Trump effectively did. It's a non sequitur. It drives me crazy reading it. It's on page 42 of the brief for anyone who wants to go back and just, lose their mind.